Complete Guide to Tourism, Leisure and Family Visit Visa. In today's video, we discuss in detail about the Tourism, Leisure and Family Visit Visa. The Tourism, Leisure and Family Visit Visa is for people who wish to visit the UK for a temporary stay for visiting friends and/or for a family vacation.
The UK
points-based
immigration system.
ending free movement.
But change is coming. Change is coming.
The Tourism, Leisure and Family Visit Visa is a subclass of the Standard Visitor Pathway, which is a pathway for people who plan to visit the UK for a short time period of 6 months. Tourism, Leisure and Family Visit Visa Immigration Rules. Under Appendix V of the Immigration Rules, there are 4 types of visit visas. Standard Visitor. This visa is for those looking to perform the activities mentioned in Appendix Visitor Permitted Activities, such as visiting family and tourism, usually for 6 months. A standard visitor may apply for a visit visa with the validity of 6 months, 2, and 5 or 10 years, but the period of each stay must not go beyond the allowed time period of stay mentioned on the visit visa, which is mostly of 6 months. Marriage Civil Partnership Visitor. This visa is for those who are looking to come to the UK to form a civil partnership or marry, or to give notice of marriage or civil partnership. Permitted Paid Engagement Visitor. This visa is for skilled experts in their respective fields coming to the UK to take on specific paid jobs tasks for 1 month. Transit Visitor. This visa is for those who want to transit the UK en route to another country outside the common travel area and who will enter the UK for up to 48 hours by crossing the UK border unless Appendix Visitor, Transit without visa scheme applies. What are the usual conditions for a Tourism, Leisure and Family Visit Visa? You are a visa national. A non-visa national can normally seek entry as a visitor on arrival at the UK border. You are pursuing entry into the UK for a reason that is allowed by the visitor pathway. You will not participate in any prohibited activities. You have adequate finances to take care of all the reasonable costs related to your visit, which includes maintenance, accommodation, and travel costs without having to work or requiring public funds. At the end of your visit, you will leave the UK. You will not be living in the UK for longer periods through your repeated or following visits, or make the UK your main residence. Your application does not come under the general grounds for refusal and is rejected. All the guidelines are provided to caseworkers in the Visit Guidance, version 11.0, issued for Home Office staff on the 6th of October 2021. Visa or non-visa national. You will first need to make sure whether you have to apply for entry clearance prior to travel. Immigration Rules Appendix Visitor. Visa national list includes a list of countries that are required to apply for entry clearance beforehand except for the exceptions mentioned in VN 2.1 and VN 2.2. Subject to VN 2.3 or VN 3.1 are applicable. Those that are non-visa nationals should consider applying beforehand if, for instance, there is unfavorable immigration history and you have been declined entry previously. Making an application in advance can provide security and certainty. The conditions for the Tourism, Leisure and Family Visit Visa have to be fulfilled by non-visa nationals as well, but this is analysed at the border by an immigration officer. Making a valid UK visit visa application. The conditions for legitimacy for entry clearance or permission to stay as a visitor are specified in paragraphs version 2.1 to version 2.6 of Appendix V. A candidate should apply using the suitable online application form, pay the charges that are applicable, and provide biometrics. Entry clearance applications must be made from outside the UK. Common causes for refusal and immigration status required. You will have to make sure that any of the conditions in Part 9 of the Immigration Rules apply. Mainly, Part 9 covers criminality, harmful grounds, false representation and deception, previous violations, and other non-compulsory grounds. Some grounds are obligatory and others non-obligatory. It is important to make sure that you answer all questions on the form truthfully and be transparent. Any incorrect information you provide can be a cause for rejection and a ban, meaning that future applications to enter the UK will be declined. If a candidate is applying for approval to stay, they must not be in violation of immigration laws or on immigration bail. In case paragraph 39E applies, the period of extended stay may be ignored. Version 3.1 and version 3.2. Legitimate visitor. You will need to show that you are a legitimate visitor. The guidance for caseworkers refers to an evaluation of the candidate's personal circumstances, including the previous immigration history of the candidate, including travels to the UK and other countries, the length of their previous travels and whether their stay was considerably longer than they originally stated on their visa application or on arrival. If they overstayed, it should not automatically be presumed that the candidate is not legitimate, but this may be a reason to raise a question on the candidate's overall intentions. The financial situation of the candidate as well as their social, economic, and family background. Their economic and personal ties to their country of residence. The collective period of time the candidate has visited the UK and their pattern of travel in the last 12 months, and whether this can be considered as de facto residence in the United Kingdom. Whether the information and the reasoning for their visit or prolonging the stay given by the candidate are convincing and in line with their personal, family, social and economic background. The guidelines continue by specifying the reasons that can cause doubts regarding if someone is a legitimate visitor or not. Those reasons are the following. The candidate has few or no family and financial ties to their country of residence, and has a few family members in the UK. For instance, an individual with most of their family in the UK and no employment or study in their own country may be looked at as having few ties to their home country. The candidate, their sponsor in case they are visiting a friend or a relative or other immediate family member has, or has tried to mislead the Home Office in a previous application for entry clearance, permission to enter or stay. There are inconsistencies between the statements made by the candidate and the statements made by their sponsor, especially on matters where the sponsor is expected to know the details and facts but does not. It has not been possible to authenticate the information provided by the candidate despite attempts to do so. The information that has been submitted or the reasons for the visit stated by the candidate are not reliable. A search of the candidate's baggage and vehicle at the border discloses items that show that they plan to work or live in the UK. To validate these conditions, you will need to provide full details of ties to the UK, financial and personal, as well as ties to your home country. Visit visas can be complicated and need a range of proof. This proof can be in many forms, including letters and statements to support and explain documentation from different sources. Duration of a visit visa. It is feasible to apply for a long-term visit visa of around 2 years, 5 years, or 10 years. You may come and leave the UK on different occasions during the validity period, except if your visit visa is approved with a single entry. You must make sure that each visit is no longer than 6 months from the date of your entry. If you do not have an ongoing reason to visit the UK, you may consider applying for a 6-month visit visa. Even when you apply for a long-term multiple entry visit visa, you may only be awarded a visa of short duration. The guidelines state the following. You can provide a shorter duration visa if the candidate fulfills the visitor rules related to their visit, but you are worried about awarding a long-term visit visa. Entry clearance officers should acquire the authority of the entry clearance manager prior to issuing a visit visa for a shorter time period than the candidate applied for. You should give clear reasons for the decision to issue a visa of a shorter duration than that applied for in the cover letter when the passport is returned. It is noteworthy that no refunds, whether full or partial, will be given using a multiple entry visit visa. There is no specific maximum timeframe until when a person can stay in the UK during a 12-month period if it is for no longer than 6 months from each entry, but you will need to be careful not to make the UK your residence through frequent visits. This will create a consideration when you intend to make your trips to the UK. There is no specific maximum time period, which a person can spend in the UK in any period, such as 6 months in 12 months, providing that each visit does not surpass the maximum limit for that visit, which is usually 6 months. But, if it is clear from a candidate's travel history that they are planning to remain in the UK for a longer time period or make the UK their residence, you should decline their application. The fact that a candidate is provided with a multiple entry long-term visit visa does not mean that they have assured entry each time they come to the UK. Their situation may be assessed at the border, and you would be advised to keep evidence regarding any current circumstances. Whether a person is making the UK their home through frequent visits will be one matter that will be taken into consideration. The guidelines make reference to a number of aspects that will be considered. The purpose of the visit and intended stated duration of stay. The number of visits made over the past 1 year, including the duration of stay on each occasion, how much time has passed since the last visit, and if this means that the person will be spending more time in the UK than in their home country. The reason for return trips to the candidate's home country or trips out of the Common Travel Area, CTA, and if these are used only to acquire re-entry to the UK. The ties they have with their home country or ordinary country of residence, especially analyze any long-term commitments and where the candidate is registered for tax purposes. Evidence that the UK is their main place of residence, for instance, if they have registered with a general practitioner, GP, or if they send their children to UK schools. The history of preceding applications, for instance, if the visitor has previously been declined under the family rules and successively wants to enter as a visitor, you must analyse if they are using the visitor pathway to escape the rules in place for family migrants joining British or settled persons in the UK. According to the guidelines, at the border, the candidate may be asked for supporting documents. Depending on the questions asked and the answers provided. Maintenance and accommodation, what are the levels and who can provide this? As part of the conditions for a legitimate visitor, paragraph version 4.2, you will be required to demonstrate that you have adequate funds, paragraph V4.2e. There is no fixed level of funds required for a candidate to show they will maintain for their visit to the UK. In analysing whether there are adequate funds, the caseworker will have to consider the conditions in paragraph 5.4.3. A third party can provide support. This may include family members, family, and other persons with whom the candidate has a genuine professional or personal relationship. You will have to consider the following aspects mentioned in the guidelines and provide evidence for the following. The history of the third party's previous sponsorships. The relationship between the sponsor and the candidate. How and where did they meet? How do they communicate and how frequently? If accommodation and maintenance are to be given by a third party, that third party should not be in the UK in violation of immigration rules at the proposed date of entry or the application. Additionally, the candidate will need to demonstrate they have the sources to provide the financial support as well as for anyone else that is dependent on them. There are many ways to provide proof for these conditions, and you will have to make sure that any concerns are addressed. You will need to show that the funds are kept in an accredited financial institution under FIN 2.1 in Appendix Finance. Regarding the finances, the candidate will need to provide evidence of their sources of income and savings. They will need to take into consideration providing proof for how long they are absent from your employment or business, and who will cover for them. The candidate should consider how to address the transactions of payment from their account, especially any recent payments before the date of application. The candidate may consider providing the details of charges to show that the funds being held or the funds they depend on are sufficient according to their needs. For instance, their costs may be less if they are staying with family and don't require to contribute to daily living expenses such as food. There are many ways to provide this evidence. We have reached the end of today's video update. Like, share and subscribe to our channel for more latest updates. Thanks for watching.